In the High Court of South Africa, Limpopo Division, Polokwane, case number 2963 of 2024, in the matter between Benja Enterprise as the plaintiff and the Minister of Public Works and Infrastructure as the defendant. Notice in terms of Rule 49:18. Be pleased to take notice that in terms of Section 18 of the Superior Courts Act, the plaintiff will on Thursday, the 26th day of September 2024 at 10:00 or as soon thereafter as the parties may be heard, apply for an order declaring that the matter be enrolled in terms of Rule 612. The order or judgment issued on Thursday, the 12th day of September 2024 by the Honorable Morgan A.J. is unconstitutional, unlawful, or invalid and is set aside. Payment of the sum of 4,949,582 rands and 99 cents inclusive of value-added tax. Interest on the sum of 4,949,582 rands and 99 cents inclusive of value-added tax at the rate of 24% per annum calculated from 26 March 2024 to date of payment, cost of suit, and that the supplementary affidavit of Lieutenant Commander Sylvester Volane Mangolele will be used in support of the application. To the registrar, kindly set the matter down in accordance with the above information. And the supplementary affidavit on the matter is done by the undersigned force number 99004046MC, Lieutenant Commander Sylvester Volane Mangolele. Do hereby make an oath and say, I am a citizen of the Republic of South Africa, equally entitled to the rights, privileges, and benefits of citizenship, and equally subject to the duties and responsibilities of citizenship as obligated in terms of Section 3 of the Constitution. And I'm a volunteer who did not swear an oath he can't uphold. And the African Charter on Human and People's Rights at Article 29.8 imposes a duty for all individuals to contribute to the best of their abilities at all times and at all levels to the promotion and achievement of African unity. To any person who does not know the term locus standi, is a Latin phrase whose literal translation means place of standing and whose definitive use is the right of a party to appear and be heard before a court. As the Honorable Court has sworn solemnly affirmed that it will be faithful to the Republic of South Africa, will uphold and protect the Constitution and the human rights entrenched in it, and will administer justice to all persons alike without fear, favor, or prejudice in accordance with the Constitution and the law, so help me God. I have pledged to serve and defend the country and its people in accordance with the Constitution and the law, and with honor, dignity, courage, and integrity. And what I carry on my shoulders is one sovereign, democratic state founded on the following values: human dignity, the achievement of equality, and the advancement of human rights and freedoms; non-racialism and non-sexism, supremacy of the Constitution and the rule of law, universal adult suffrage and a national common voters roll, regular elections, and a multi-party system of a democratic government to ensure accountability, responsiveness, and openness. I am national security, a peace officer or a justice of peace holding a permanent commission to a rank of lieutenant commander with force number 99004046MC, and cannot desert my duty to the defense force as obligated in terms of Section 13 of the Military Discipline Code, obligating that any person who is subject to this act who deserts from the defense force is guilty of an offense and liable on conviction, if he or she committed the offense while on service, to imprisonment for a period not exceeding 20 years, and in any other case, to imprisonment for a period not exceeding 10 years. The Bill of Rights applies to all law and binds the legislature, the executive, the judiciary, and all organs of state as obligated in terms of Section 8(1) of the Constitution, and in terms of subsection 2 therein. A provision of the Bill of Rights binds a natural or a juristic person if and to the extent that it is applicable, taking into account the nature of the right and the nature of any duty imposed by the right. The plaintiff as a juristic person is entitled to the rights in the Bill of Rights to the extent required by the nature of the rights and the nature of that juristic person as obligated in terms of Section 8(4) of the Constitution. And subsection 3 therein imposes an obligation that when applying a provision of the Bill of Rights to a natural or juristic person, in terms of subsection 2, a court, in order to give effect to a right in the bill, must apply, or if necessary, develop the common law to the extent that legislation does not give effect to that right, and may develop rules of the common law to limit the right, provided that the limitation is in accordance with Section 36(1). It is submitted that the plaintiff suffers irreparable harm as a result of law or conduct that is inconsistent with Section 38 of the Constitution and the law at Section 4(1) of the Consumer Protection Act. And such irreparable harm is not only suffered by the plaintiff alone, but also his representative, which is myself, the country, and its people, that must be served and defended in accordance with Section 38 of the Constitution and the law at Section 4(1) of the Consumer Protection Act. It is submitted further that there is no term LLB qualification mentioned at Section 38 of the Constitution and the law at Section 4(1) of the Consumer Protection Act, and the order by the Honorable Morgan A.J. lacks discipline in that effect. And the plaintiff is obligated in terms of Section 9(2) of the Constitution to the full and equal enjoyment of all rights and freedoms, which can only be enforced with discipline to the obligations imposed in terms of Section 38 of the Constitution and the law at Section 4(1) of the Consumer Protection Act. The order or judgment issued on Thursday, the 12th day of September 2024 by the Honorable Morgan A.J. is a manifestly illegal order intended to cause Lieutenant Commander Sylvester Volane Mangolele to desert his duty to serve and defend the country and its people in accordance with the Constitution and the law, and as obligated by the Code of Conduct for Uniform Members of the SANDF, Section 1996 of the Constitution and the law at Section 2E of the Defense Act. Lieutenant Commander Sylvester Volane Mangolele cannot obey a manifestly illegal order not to serve and defend the country and its people in accordance with the Constitution and law, and the order or judgment so issued must be set aside as it only unlawfully impairs, violates, threatens, or endangers the existence, independence, or security of the Republic. It must be set aside as it only unlawfully changes the constitutional structure of the Republic. Such order must be set aside as it only unlawfully overthrows the government of the Republic, and it only obstructs or interferes with the Defense Force in the execution of its duty in accordance with the Defense Act or the Constitution. And such order must be set aside only induces or attempts to induce Lieutenant Commander Sylvester Volane Mangolele as a member of the Defense Force to neglect or to act in conflict with his duty to the Defense Force, and it undermines or stifles or seeks to undermine or stifle a procedure for the redress of grievances. A judge must at all times also in relation to extrajudicial conduct comply with the law of the land as obligated in terms of Article 6 of the Code of Judicial Conduct, shall comply with the law of the land in the Defence Act at sections 104.10, section 104.11, section 104.17, obligating that any person who obstructs or interferes with the defense force in the execution of its duties in terms of this act or the Constitution is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 25 years. Any person who induces or attempts to induce any member of the defense force to neglect or to act in conflict with his or her duty to the defense force is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years. Any person who undermines or stifles or seek to undermine or stifle any procedure for the redress of grievances is guilty of an offense and liable on conviction to a fine or imprisonment for a period not exceeding 5 years. It is incumbent for any peace officer to, without warrant, arrest any person who commits an offense in his presence as obligated in terms of Section 40 of the Criminal Procedure Act, and I wish not to debate with any person equal before the law, including a judicial officer. For the defense force must be structured and managed as a disciplined military force as obligated in terms of Section 201 of the Constitution. I appear before a competent court as national security or a peace officer to resolve a dispute by the application of law decided in a fair public hearing as obligated in terms of Section 34 of the Constitution and the law at Section 9(1) of the Superior Courts Act. For I must act and am taught to act and required to act in accordance with the Constitution and the law, including customary international law and international agreements binding on the Republic as obligated in terms of Section 1995 of the Constitution. The notice before the Honorable Court is in terms of Rule 4918, which provides that, notwithstanding the provisions of this rule, the Judge President may, in consultation with the parties concerned, direct that a contemplated appeal be dealt with as an urgent matter and order that it be disposed of, and the appeal be prosecuted at such time and in such manner as to him seems meet. Any judge must comply with the law of the land at Section 237 of the Constitution, obligating that all constitutional obligations must be performed diligently and without delay. And the constitutional obligation to be performed diligently and without delay is at Section 38 of the Constitution. Following law or conduct manifested by the order or judgment issued on Thursday, the 12th day of September 2024 by the Honorable Morgan A.J., which is inconsistent with the obligations imposed in terms of Section 38 of the Constitution and the law at Section 41 of the Consumer Protection Act. Therefore, the urgency of this matter giving effect to the applicable terms at Section 172 of the Constitution for the court to declare that any law or conduct that is inconsistent with the Constitution is invalid to the extent of its inconsistency, and for the court to make an order that is just and equitable, including an order limiting the retrospective effect of the declaration of invalidity and an order suspending the declaration of invalidity for any period and on any conditions to allow the competent authority to correct the defect. The Honorable Morgan J. willfully or gross negligently refused to correct the defect as explicitly set out in the notice in terms of Rule 42(1)B at page 57 to 68 on record of court. The competent authority to correct the defect in terms of Section 38 of the Constitution and the law at Section 41 of the Consumer Protection Act, respectfully obligating that enforcement of rights is such that anyone listed in this section has the right to approach a competent court, alleging that a right in the Bill of Rights has been infringed or threatened, and the court may grant appropriate relief, including a declaration of rights. The persons who may approach a court are anyone acting in their own interest, anyone acting on behalf of another person who cannot act in their own name, anyone acting as a member of or in the interest of a group or class of persons, anyone acting in the public interest, and an association acting in the interest of its members. Realization of consumers' right is that any of the following persons may, in the manner provided for in this Act, approach a court, the tribunal, or a commission alleging that a consumer's right in terms of this Act have been infringed, impaired, or threatened, or that prohibited conduct has occurred or is occurring. A person acting on his or her own behalf. An authorized person acting on behalf of another person who cannot act in his or her own name. A person acting as a member of or in the interest of a group or class of affected persons. A person acting in the public interest with leave of the tribunal or court, as the case may be, and an association acting in the interest of its members. Granting the relief sought will only uphold and defend that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid, and the obligations imposed by it must be fulfilled. And the court must respect, protect, promote, and fulfill that everyone has the right to freedom and security of the person as enshrined in the Bill of Rights. It is clear that LLB qualification is not the only person or measure that can be used to cause the plaintiff further irreparable harm to human dignity, the achievement of equality, and the advancement of human rights and freedoms. For God has indeed blessed Africa. Papa Uteng.